What's going on, you? This is Instructor Mike. You can follow me on Facebook at Mike Brown or Instructor Mike. Follow me on.
It could be you as a citizen, and you walked up and you see somebody. Look heavy. I don't know. Create special. That must be. But it's good to know that this can handle the high pressure rounds of the flooding. Ready to go.
Make eye contact with me. He's still trying to get it open a couple of times.
So champ. What's going on? What's going on? I don't think I'm live on all the platforms. Okay. Yes, I am. Okay. Let it come through. Let it come through. What's going on, Gail? I saw you here early. You said, do I have an end of the year concealed carry class? No, I don't. No, not till at the beginning of the year. What's going on? What's going on? Hey, Gail at night. How are you doing? Hey, I got to see. Send me your email again, Gail. I've been trying to look for it and I didn't get it. I did not get it. What is going on? What's going on? We are going to talk about CCW safe and what happens during the criminal trial process. If it is not too much trouble, would you all go on ahead and get the likes up, please? If it's not too much trouble, you said, this is my first time in your live. Glad to be here. Thank you. What's going on? What's going on? Yeah, I'm looking off to the side. I gotta kind of scoot stuff over a little bit because my computer, so that way I'm not necessarily staring off too far to the right. Sorry about that. Just make a little adjustment here and things are falling. It happens. Yeah, doesn't it? Hey, Chrissy, what's going on? Uh-oh. Buddy JFB is sick with the vid. Sick with the COVID. You said, I've got mine so far. I feel a lot safe. What do you mean, Speed Demon 6? Speed Demon 666. Du hast, Mitch. James K, what's going on? Gail, thank you as always. You know, this is a very interesting conversation that we're going to have tonight, and it's going to grind some gears. It's going to grind some gears tonight. It's going to grind some gears. Those of you all who know the two companies that are out there, USCCA and CCW Safe. Well, if you remember some time ago where I sat there and talked about concealed carry insurance versus concealed carry legal services membership. So I felt, and I'm going to go on ahead. Gail, send me that email again so I can respond to that. Practical Kid, what's going on? Patah, what's going on? If we can get the likes up, I would greatly appreciate that. Plus, if you appreciate the content, and this is going to be a pretty good show. I like to think it's going to be. I like to add value. Those of you all who are out there who are carrying a firearm for your own self-defense and the defense of your family, it is important that you understand the aftermath of after you pull that trigger. Now, those of you all who followed me, I'm going to read the comments shortly. Those of you all who follow me, you know that you said someone is trying to get Mike to do a CCW class on New Year's Eve near midnight. You guys are funny. I haven't been doing gun classes since August. How many of you all would like to know why I haven't been doing gun classes since August? It is an egregious constitutional violation, an egregious constitutional violation. What happened to me and approximately 10,000 people in the state of Illinois. And it has a lot to do with the clear and present danger stuff that took place July 4th. And I have to be cautious about what I say, not because I don't want to tell you. It's not because I don't want to tell you. This is a heavily politicized thing that took place, not only to me, but approximately 10,000 people in the state of Illinois. And it is so egregious of a constitutional violation. I didn't do anything to deserve it. Neither did those other people do anything to deserve it. But we are all going through it. So I'm going to err on the side of wisdom, and I'm going to state that this egregious constitutional violation of the Second Amendment, hopefully it should work itself out. And when I am done with this, and hopefully everything is back to where it should be, I will hopefully be at more liberty to discuss what has taken place. Okay. It's extremely sad. But I will tell you this, the anti-Mike Brown folks, the anti-instructor Mike folks are loving it. But I will tell you this, I have become a much better advocate for those who have found themselves going through situations and revocations, and those who have needed to get mental health evaluations. Not stating that I am such a person. For the record, I did go through a forensic mental health evaluation and passed it. Nothing's wrong with me. But that mental health evaluation, it was awesome to go through, okay? Because it enables me to be able to give you more insight as to what to look forward to if you are a licensee in the state of Illinois. If you value anything I have ever taught you, a smart person learns from their mistakes. A wise person learns from the mistakes of others. And when I sit here and tell you that you need to avoid conflict, you need to avoid conflict. When I sit here and I tell you that it is very easy for people who don't like you, and including your loved ones, and I use those in air quotations, right, to attack the very thing that causes you to protect yourself and or feed yourself and or your families. That is what people will do. So when I tell you, if you are a resident of the state of Illinois, make no mistake that this is an anti-gun state. Remember, they did not want to give residents of the state of Illinois the right to be able to protect themselves. That was a fight to even get what we have now. Shouts out to Rhonda Ezell with Chicago Guns Matter. Shouts out to the NRA in McDonald versus Chicago. Shouts out to the Heller Foundation and Dick Heller in Heller versus District of Columbia. Those people, including Otis McDonald, they paved the way for Illinoisans to be able to carry firearms legally. But if you thought this was going to be an easy win, guess again. You forgot what state you are in. You are in Custer's Last Stand, for those of you all who get the reference, right? Illinois was going to die on that hill and deny us the right to be able to protect ourselves. They had to be forced to do so by the United States Supreme Court pursuant to McDonald versus Chicago, right? Now, I think it was NRA versus Chicago or McDonald's versus Chicago. Either way, one of the two, right? Now, what they are trying to do is find a quicker way. No thanks to Robert Crimo, July 4th, Highland Park. The controversy over clear and present danger. If you think that red flag laws are your worries, you have no effing clue. If you think that red flag laws are what you have to worry about, which is a judicial process, you have no effing clue. Clear and present danger is far more dangerous than red flag laws. So when I tell you, if you are a gun owner, I don't care if you have to leave the house and walk away from your husband and children, your wife, and I don't care if an argument broke out and you just stop arguing and beat feet. Do it. Pull out that phone, record, and walk clean away. Now, I know you don't value what I'm saying. I know you think you have a handle on things. I know you think that in your infinite wisdom, you're gonna be okay until you find yourself going through a situation and then you call me or someone better than me. And then you ask us for our advice about what to do. I got my concealed carry, FOID card, and other things revoked. When you begin to ask us those questions, and I'm very good at expungements, very good at helping people on FOID and concealed carry appeals. Unfortunately, during this ordeal, I've had a lot of practice. A lot of practice. You'll then begin to understand why I told you avoid conflict. And we're going to get to the CCW safe stuff shortly because I just feel I need to say this stuff, right? The best tool that you have in your arsenal is the 6 inches between your ears, and that is to not argue, walk away. I'd rather make someone upset because I walked away than to get into an argument, win the argument, but lose your Second Amendment rights. Trust me when I say this. Trust me when I say this. Okay? So, that having been said, let's get to the topic of discussion. What's going on, Mark? What's going on, you all? Well, Brian, hold on. Well, verbal jujitsu, no. What's going on, Mark? No. We are not talking about verbal jujitsu, guys. No. If you value anything, please, if you've never listened to me ever and you live in the state of Illinois, please, I beg of you, and you have never heard me use that word beg. This is not about verbal jujitsu. No, I know what you mean, Brian. I know what you mean. I know what de-escalation and verbal jujitsu is. Trust me, I know it. I have a video that went viral, 3 million plus views about me de-escalating something. I know what verbal jujitsu is. Practical Ken said it best. No verbal sparring at all. Like, walk away, clean, just silence, walk, say nothing. at all. I'd rather walk away clean, recording myself walking away, than to sit here and get into a verbal sparring match where even in using verbal jujitsu, I end up getting a clear and present danger report filed against me. Does that make sense? Just walk away. Just walk away. Now, Mark said they even get more mad when you walk away and act like the bigger, better person and don't feed into their BS. That's why you pull out that phone and have it on record, and you record every and anything. Record them attempting to put their hands on you. Record that stuff. Record it. I'm just saying, man. Trust me on this. That's what it's called, Rob. It's called get your up and run away from a domestic situation. I'm trying to refrain from cussing so much. Not that I don't want to cuss, but you get what I'm saying. Giovanni, I got your message. Or, I'm sorry, I done called you a whole new person. Gigi, I got you. I got your message. Right? Walk away. If you are a resident in the state of Illinois, it does you zero benefit to get into any argument with anyone. Be silent and be thought of as a fool than to speak out and lose everything. I'm telling you, the state of Illinois is not playing, and they have a tool in their arsenal, and it is easy, extremely easy for them to use. I don't want to say, you see what I'm saying? I got to be careful about what I say, because if I say what I say, yes, that's my correct email address. Yes, that's correct, Gail. If I say what I say, it's given a blueprint to the people who may not like you. Does that make sense? It's given a blueprint. So I got to be careful about what I say and give you the best advice. And that is to walk away. Men, I don't care if it is your wife. Walk away. Shut your mouth and walk away. If you think you got power, I'm the man. I'm an alpha male. Oh, you're going to find out the hard way. Walk away. Walk away. Ladies, if you think, walk away. Just walk away. Divorce papers will be on the table by walk. If you value it, you don't have to like me. I know it. I'm pleading with you. You don't have to like me. When I started this channel, I did not have as many followers or subscribers. I didn't have that in mind. When I started my Facebook page, I didn't have that in mind. I became viral. I wasn't looking to become viral. So I didn't have that in mind. Look, you don't have to like me. But if you like you, if you value you, let it go. Walk away. Just walk away. Please. Because the state of Illinois and the Illinois State Police has a egregious constitutional violating tool in their arsenal that they can only use if ... I'll never say it. Walk away. Just walk away. Don't even say, well, fine, Keisha. Oh my God. Well, listen, Mary. Don't you love just walk away. Just walk away. Don't have any last words. Just do this. Just do this. And just walk away. Just walk. No, Jack. See, that's what I'm talking about. You can't even behave in the comments. He said, goodbye, Karen. No. No. Just walk away. Practical Kid. StreamYard has been tripping. And it's not just on me. It's everybody. Here we go. Easier said than done, though. Hard to not respond when people push your buttons. Practical Kid, I appreciate you for being honest and saying what people may be thinking, but they didn't say. But I'm going to tell you this. That's where that anger management training comes in. That's when understanding you and your triggers come in. That's where understanding and getting more tools and more positive coping mechanisms that give you the confidence, the knowledge, skill, and ability to walk away. And I'm going to say the last thing, and then I'm going to go on ahead and move on to this CCW safe, because that's why you're here. Come here, let me tell y'all something. Can I keep it real with y'all? I'm not gonna cuss. I don't need to use my college professor language, right? I don't care if you have to walk away from your wife, from your husband, from your mother, from your father, from your daughter, from your son. I don't care how old, how young, how hurt, walk away. Walk now, or you won't get to walk at all. Walk away. The power and influence that you think you may have, you may not have, or you may have lost in that moment. I don't care what kind of names they call you. That's where realistic self-esteem comes in. You are not what they call you, but don't give them a reason to have something real to label you as. Walk away. Walk away. Walk away. Now I'm going to look at these comments and we're going to get to it. You said, is it true that they changed the domestics in Illinois to anyone you've had an encounter with, not just relationships? I haven't heard any statutory changes to that. I'm going to look that up and get back to you. I don't think that would even be, I would have to see about that. You said, yes, use jazz hands and walk away. Keep them scratching their head on WTF, what the F just happened. When you catch your partner cheating, walk away. Right? You're not wrong either. I'm just saying, right? All right, here we go. Let's go ahead and get right to it, because that's why you came. We're going to talk about CCW Safe. Now, I know people have asked me about the right kind of insurance or legal services product that you should get. I'm just going to let you know, you have heard me talk about USCCA here. I don't have USCCA. I got it as a complimentary membership. I did not pay for that. I don't have USCCA. I stake my life, this body right here, I stake it on CCW Safe. How many of y'all knew that already? How many of y'all knew? If y'all knew that, sound off in the comments. I knew it. How many of y'all knew that already? And I'm going to show you why. Out of their own mouths. Out of their own mouths, because I think this is important. And this is a react video that I'm going to react to this wonderful criminal trial process. You said, I remember from your class. Tino said, I knew that. I've been following you for quite some time now. Now, don't get me wrong. If you want to choose USCCA, you're more than welcome to. They're great people over at the USCCA, but I like CCW Safe, and I'm going to tell you why. As a former police officer, right, I know the kind of protection that police unions, for the most part, provide their members. I know the kind of protection they provide their members, right? CCW Safe is built on that model. But I'd rather you hear it straight from them in this wonderful episode of the CCW Safe Podcast, episode 101, the criminal trial process. You see that guy over there in the black suit and red tie? That is National Trial Counsel Don West. I have personally or professionally talked to him directly. A great and knowledgeable man and an attorney, right? He's just great. And I'm talking about professional, right? Remember when I told you all, well, if the link is in the description. If you're watching on YouTube, right, I'll put the link right here. I know Gail has done that. I'm going to put it in there, and it does have my referral code. Yes, yes, please. Thank you. You know, yes. And yeah, please, maybe. No? Just a little bit? Okay. CCWSafe.com /Sextricon. So I'm going to put that there. There we go. And you said share how much. Let me tell you how much I pay for the whole year. For the whole year, I think I only pay like what? 200 something? Maybe not even 200 for the whole year. Yeah. Yeah. And their coverage works. Can I say I hate to? That's not the referral code. If you click on the link, the whole thing will come up and it'll be up under my stuff, right? But here's this. Remember when I told you, or when I asked you, if in this climate, you said for some reason it's not linking. Is McDermott still covered under CCW Safe? Yes, he is. Yes. Oh, yes. Dave McDermott is still, I personally know this. Dave McDermott is covered because Dave is not specific to USCCA or to CCW Safe. Dave McDermott is a wonderful criminal defense attorney who is great at his job in vociferously, viciously, professionally defending his clients. And Don West is great. Thank you, Gail. Don is great at vetting counsel to make sure they are great at their job. Don has texted me directly. Don does not play. Don is very good. And I'm going to tell you how good he is. It's going to piss some of y'all off. You ready for me to piss you off? He was George Zimmerman's attorney. Oh, God, no. Lord, look at some of y'all. I knew it. Look, you don't have to like the outcome. I knew George Zimmerman was going to get acquitted. I knew he was going to get acquitted. The facts and circumstances, when you take your emotions out and you look at the law, I knew he was going to get acquitted. Those of you who have been following me for a long time, you knew I said it. He did his job, like it or not. Don West is a great, look at you, Art. I knew, look at y'all, I'm about to cuss. Okay, so this isn't about Trayvon Martin. This is about getting you the best service you can get for when you are in a situation that you attempt to avoid. Remember what I said earlier. And I'll give you one even better. In this climate, if you are found guilty, because in Illinois, it's possible. If you are found guilty, will CCW Safe cover you during the appeal? We're about to watch this, and I'm not going to answer that question, boy. Look, I'm going to stay in my lane, and I'm going to let this play. All right? Look at y'all. Let's get right to it.
I'd like to welcome everybody to the CCW Safe Podcast. I'm your host, Rob High, here in Oklahoma City, and today we have some members of our team that we want to introduce to you. Sean Vincent here on my right, your left, and our Chief Trial Counsel, our National Trial Counsel, Don West, on my left.
Hey Rob, good to be here.
Good to have you guys. Part of our service is our critical response team. You guys have heard an awful lot about what Gary does and I do. But as we proceed on, a lot of the things that you have questions about pertain to the next course of action, the next step, where we're going in the legal process. And we've got the best two guys in the company to talk about that today. So Sean, if you can give us just a minute or two and kind of let our folks know what it is that you do for us.
Sure. Well, yeah, I'm a litigation consultant, which means I stopped going to school after I got my English degree. And I never imagined that I'd be involved in anything involving the legal industry until I crossed paths with Don.
So you have both an English degree and a job?
And a job, yeah. I've defied all expectations. I'm a unicorn in that regard. Yeah. But when I crossed paths with you on the Zimmerman case, that was, ironically, I was there in the capacity of helping handle the public perception of the criminal defense, manage the media, the social media aspects of it, but that was kind of an all hands on deck enterprise.
Yeah.
And you came on board, and then I had the amazing opportunity to see the insides of a criminal defense, especially for a self-defense, which is unusual compared to almost all other criminal defense type cases. And then we had the trial. I got to be involved in helping qualify the jury and just being the eyes and ears outside the courtroom while the drama was unfolding inside. And after that, I got a chance to be involved in dozens of cases, a lot of self-defense cases, and I've been writing and researching and studying self-defense for 10 years now.
Quite a long time, actually. Gary and I, if we respond to your incident, part of that is kind of walking you through the steps. As far as, we're going to get you set up for a formal interview. We'll do these things and make sure any kind of peer support needs are met for you. If it's at your home or something like that, we need a crime scene cleanup, we'll facilitate those kind of things. But beyond that, it really moves into Sean and Dawn's realm. So Dawn, once this is established, and whether it's a charge that is being presented by the investigations team to a district attorney, or if it's something that's going to go in front of a grand jury, depending on where you live and how they basically file cases. What are the steps now that are coming out for them?
Sure, and each jurisdiction will have differences, but it's pretty predictable what's going to happen.
Right.
You get to a point, and then either this is going to happen or that's going to happen. Right. And depending on which it was, you'll go this way or that way. So I think it would be great today to talk about what is that process, the stages of a criminal prosecution. For sure. And where do you get from arrest until there's a verdict or beyond. So I think that'd be great. I'd love to talk about that.
Yeah, well, as an investigator, if I am the case agent, I'm assigned to this, I would conduct all my investigation and utilizing whatever other resources, whether it's crime scene investigators and the work that they do, or the DNA lab, or whatever other things that come into play for me. And I put everything together, and then I go sit and discuss with prosecutors in the district attorney's office. And a lot of people don't understand. They just think, well, the cops did this and the cops did that. I put all the case facts together and I present those to the prosecution, and they're the ones that determine what charges or if charges are going to be filed. So they may direct me to go ahead and prepare a probable cause affidavit with facts of the case, and we move forward and get an arrest warrant. Sometimes we can arrange that with an attorney to have them come in and walk you in and surrender and do things like that. But beyond that, once an arrest has been made, even if it's just a deal where I have to do a walkthrough and they take my fingerprints and photographs and get all my things done like that, now we're moving into the legal system. So
the listeners have a good idea what you're talking about. You talk about all that work that's gone into it before an arrest is made or charges are brought. That could be days, that could be weeks, where from between when the incident happened and the defender is waiting to find out what are the police going to decide, what's the prosecutor going to decide, am I going to face charges, and when I do, when are they going to come and what are they going to be?
Yeah, exactly right. So let's start at the point of the incident. There's going to be a law enforcement response. Now we're talking about a serious self-defense scenario, lethal self-defense, shots fired, somebody's hurt. So it's the real thing.
Right.
We need boots on the ground right away. We need legal advice to the member right away. But that may not actually occur until, and isn't likely to occur before there's an initial police response. And at that time, there's going to be some questioning by the police, an attempt to begin the investigation, collecting evidence. There may be an arrest, and there may not be. Whatever time that takes between the incident and the arrest, whether it's a few hours, a few days, weeks, or months, and then the charging decision, from my perspective as a criminal defense lawyer, I call that the pre-charge phase.
Correct.
Right? During that time, we can have lots of input with law enforcement or the prosecutor through counsel doing some investigation. In some jurisdictions, there's some limited ability to present evidence to the grand jury through the prosecutor, for example. So this pre-charge phase is really important, but there's no way to predict how long it might be.
Right.
Sometimes an individual that could be arrested, that the police feel they had probable cause, choose not to arrest because they're not afraid that he's going to run off.
Right.
And they don't want to start the clock on the process. So they delay, they do, lab work, forensic evidence examination. There could be blood stuff, ballistic stuff, lots of witnesses to interview, videotape to gather. Well, you know exactly how thorough and big those investigations will be. But at some point in time, that package that you referred to will be referred to the prosecuting authority.
Yes.
They'll look at it, they may task more stuff, or they may decide, well, we can make our decision now. Well, the decision could be in some places, I'll sign off on the information, an arrest warrant will be issued, and the person will be in the system. Or in other places, it has to go to a grand jury.
Yeah.
Either way, it results in formal charges. And then that begins the process of the formal procedure. So once someone's arrested, they're going to be taken before a judge. There's going to be an issue addressed if they're eligible for bail, whether there can be bail set, what are the conditions, the terms. It can happen soon, or it can take several days or weeks to pull all of that information together in a serious case. But at some point, they'll be brought before a judge. The judge will decide, in a sense, probable cause. Release will be granted or not. And then you are quickly into the discovery phase. Right? There's an arraignment, you plead not guilty, then there's going to be court date set, and now you're in the discovery phase. That's the time from the formal charge until there's a resolution of the case, either by a trial or some sort of plea or dismissal. So that can be weeks or months or even longer.
Well, that
It could be either in jail or not in jail, out on bond during that time.
And you know, that makes a big difference to everyone, not just you, if you're the guy in jail, but I know as a lawyer, if my client is not in jail, I don't have to go there to visit, but more importantly, I can enlist their help in helping me understand things. He can help me identify witnesses. We can go to locations. It's so much more helpful to the case to have a client out of jail than one's in, separate and apart from what a pain it is, of course, and how emotionally, I don't know how you would describe the experience of being in jail, not just the restriction in the custody, but the idea of waking up every day in that circumstance, not knowing what your fate's going to be.
Yeah, that's huge.
Draining.
It is so taxing. That's perfect. Because it's not just to the individual that's been
struggle
arrested.
streaming. Come on.
It affects everybody. It affects your
Hold on
spouse,
for a
your
minute.
children, your loved ones.
I'm just pausing it for a minute because StreamYard is doing their struggle streaming stuff. What's up, Calvin? Yeah, I was watching somebody else's live yesterday, and StreamYard was struggle streaming. It's a lot of people who use StreamYard, so I don't know. Are you guys, is it still coming through fine, or is it kind of choppy? I'm just waiting to see in the comments what you all are saying. Good there? All right, we'll keep playing.
Your employment. It's just so far reaching. Now, once we've had this initial arraignment, we know these things are in place. As we begin to move forward, kind of from your perspective, your next steps in preparing a proper defense move what direction now?
Hopefully, from the very beginning, we've had investigators involved that can help identify witnesses with the help of our client. Begin to digest the information that's known. But soon after the arraignment in most jurisdictions, the prosecution will be required to provide information, records, documents, reports. And that's what's typically characterized as discovery. Certainly any statement that the accused has made, body cam, formal statements, oral statements that somebody made notes of, physical evidence that's been examined. That's all of the information, few limitations actually that you put together as the investigator and sent to the prosecutor's office will then be filtered, sorted. Some stuff may be withheld. But for the most part, then provided to the defense. So then the defense has a pretty good look at the prosecution case. Typically,
They always send all the information, whether it's good or bad for their case, right?
That's right, and I know that you're kidding. Not only kidding, because while that might be an ideal, it doesn't happen very often. Because there's so much information together, even prosecutors with the best intent can miss things. So you may have to request things that you think are there that they didn't give you. And we've certainly done lots of that in our careers. Then there are.
So I think it's just struggle streaming. You said, there we go. All right, let me turn it back off. Here we go.
People that may not quite be as ethical as the rules require and either limit information that clearly should have been provided or make it difficult to get or to identify, hiding the ball, essentially. Jurisdictions vary. Some jurisdictions are very open and you pretty much get everything. Other jurisdictions are a little tighter and the prosecutor has more ability to withhold stuff. But every jurisdiction, every prosecutor is required to disclose exculpatory information. That's what you were saying, right? The Brady information. If it's exculpatory, then it has to be disclosed. Just like any statement made by the accused has to be disclosed. And sometimes there's problems. Yes.
And as a defense attorney, there's no one else who's going to police that. So as the defense team has to be the ones that hold the other side accountable to make sure that they're getting all the information that they feel they're entitled to.
It's interesting because often when you look at these historical cases where someone's been in prison 10 or 15 or 30 years, and there's really been a deep dive into the record, the reason that people can be subject to a false conviction is because exculpatory information has been withheld. And in those situations where maybe it's revealed later or discovered somehow, prosecutors have gone to jail for it. It's rare, maybe should happen a little more often, at least the search should be more rigorous. But when somebody hides exculpatory evidence and it prejudices someone and they're convicted, it's outrageous and criminal.
You had asked Rob, what direction does the defense go in at this point? And it's almost a better question to say, at what speed does it go at this point? Because that discovery process takes a long time.
Yeah, it does. And Dawn had touched on it earlier because that can go for years. You know, one of the things that we learned as investigators is we over collect. If it's in my scene, I'm probably doing something to process it. You know, even something as minute as a cigarette butt, because it's a simple source to retrieve DNA from. But Dawn keeps hitting exculpatory evidence. It's just anything for my case
That really.
Chris, what was the question you were asking?
Actually could be good for the defense. Those are things that I've never had an issue with pushing everything I have out. But I've been in jurisdictions where I've seen things go horribly wrong. You know, our critical response team member, Gary, was an amazing homicide investigator. And as he was the chief investigator for the district attorney's office for more than a decade, we had a really significant homicide that occurred in a small town in the metro. And they had two different men in jail for that homicide on two different sets of facts.
So to answer your question, Chris, that's a Brady violation. Whenever evidence is withheld that is exculpatory, that's a Brady violation. And that could be, in certain cases, that's the United States Supreme Court, Brady versus Maryland, I believe that's the case, where exculpatory evidence was withheld. So if in fact that is the case, that happens in a given case, it is possible for the matter to be reversed and remanded for perhaps a new trial. So that would be what you stated, conviction overturned, which is reversed and remanded back to the lower courts for a new trial. If a trial is sent up to the appellate court or even the state or United States Supreme Court on appeal. Let's continue with this.
And you can't hold these guys right there.
I mean,
Gary saved these men's
lives actually,
because he discovers
this,
and all of a sudden
it's like
the death was either caused by this or it wasn't. And you've got completely different sets of facts for two different men. It's like
what are we flipping a coin to see which one gets caught?
And we can point out that exculpatory, we talk about exculpatory, it's not limited to clear evidence that proves innocence.
Sure.
It can be evidence that puts some aspect of the case in question or challenges other evidence. For example, if a witness for the prosecution has been made a deal in exchange for their testimony, charges dropped, a limited sentence, something like that, there's an affirmative obligation for that information to be provided. Or if a witness is a known liar, if there's history that the prosecution is aware of them lying in a prior proceeding, then all of that stuff should be produced because it would affect that witness's credibility. And if it reasonably affects their credibility, that's considered exculpatory.
Yes.
Just like any physical evidence that's withheld or something that's more clear that's exculpatory.
during this time, about every 2-3 months, there's going to be a status hearing where maybe the defender comes to be before the court, or sometimes just the lawyers show up to talk about issues related to discovery, scheduling of things, and then eventually some sort of calendar with a aspirational trial date gets put up there, right?
Yeah, the process can take weeks or months or longer. Some jurisdictions with more open discovery actually can take longer.
Yeah.
On the other hand, if there's less open discovery, the investigation that you have to do may take longer. But in any event, it's going to be weeks or months or more. To give you an example of what could take a lot of time, that seems to be something simple that could easily be resolved. In the case we were working on, the photographs taken at the scene were provided to us in black and white photocopies.
Mhm.
We couldn't get the real picture. It took weeks and demands, written letters. We then got a color photocopy, and we still couldn't get the actual digital image. And when we did get the digital image, imagine that compared to the black and white photocopy when you're looking at blood running down someone's face. The power of that, the impact, the evidentiary significance of that was overwhelming.
Right.
If we'd had that information weeks or months before, it may have changed the entire direction of the case. So sometimes every day is another fight. On the other hand, I've worked with terrific prosecutors. They do their job, they work hard, they prosecute hard, but they play by the rules too.
Right.
And I love those cases. I want the judge to know what he or she is doing. I want the prosecutor to know what he or she is doing. And I want a hard-fought case within the guidelines.
Well, and a completely investigated case. I mean,
Mhm.
you want everything to have been done. You know,
I got to remember to unmute my mic. So what he said was absolutely important. A completely investigated case. Please understand this, okay? Please understand this. During these past years, right, all these protests, things like that, you've heard people say, officer, you work for me, I pay taxes, meaning I pay your salary. Former cop here, detective, great, right? We don't work for you. The police do not work for you. It's frozen. I was frozen for a minute. And I'm freezing. StreamYard has really been tripping. Let's keep going, though. It sounds good to say, but we don't work for you. We work for the government. The government. You pay taxes to the government because if you don't, you know what happens, right? And the government appropriates that money as they see fit. One of those functions they pay for is law enforcement, because without enforcement, the rule of law has no teeth. Does that make sense? Saying all that to say this, okay? You don't know what kind of investigator you're going to get on the scene. You don't know what kind of detective you're going to get on the scene. You don't know what kind of biases they are going to come with, and as humans, we all have them. You don't know how their day has been. And though you may believe or have a factual basis to assert victimhood in this given situation, not calling you a victim, they may not share your sentiments. And this is why You need investigators who will thoroughly, in as much as they can, investigate the situation for you. Didn't I just say that CCW Safe has it set up like a police union and how they protect their members? Let's continue.
I learned several harsh lessons actually on the stand when I'd get up there and I'd have a defense attorney say, you know, these things are important, right? Yes, they are.
Mm-hmm.
Did you do this? No.
Mm-hmm.
So, you know, we grew as investigators under questioning. So it's kind of what I was saying about overproducing and giving a whole lot more. I always gave that to the prosecution. And I worked for a county where I felt really comfortable that they were going to be upfront and produce
It's the way it's
everything
supposed to work.
like the law says.
And there's a much better chance the whole process will be fair.
Yes.
If people simply do their jobs professionally
Yes.
and ethically. Even if everybody does that, that doesn't make it easy.
Yeah.
That doesn't mean it's not going to be a hard case or
Absolutely.
it's not going to be a real emotional challenge for the accused, for the victims, the shooting victim's family. All of that still plays a part, but at least you're moving from A to B in the proper ethical, professional way that the system is designed to produce whatever we now call justice.
Yes.
And for color, let's say, for example, you're not in jail, you're out on bond during this time. You've probably lost your job. You may have an ankle monitor. You may not be able to leave your house during certain times. You certainly probably won't be able to leave the county. Your life is put into a box while you're working through these issues. For all these months.
And that's likely to be the case no matter what serious crime you're charged with. But frankly, in my experience, in self-defense cases, it's almost like it's worse because more than any other case that I've handled, a self-defense case is often a good guy who gets upside down in something that's viciously attacked, has to defend himself or herself, but the way it sorts out winds up getting prosecuted. And that takes a person out of their regular life, you know, their family, their job, their networks, and turns their life upside down. You know, that's not quite so bad if it's your fourth time in prison and you just got out a week before and you get arrested again, you know. But the self-defense cases are so tough because they're so human in many ways. These are everyday folks who attempted to act responsibly and did, but
and are now being treated like a criminal.
Yeah.
Well,
in every way.
They've lived their whole lives rightly. They've always been on the right side of the law. They've always done what they believe to be right, and they've found themselves in this horrible situation that they have to defend themselves.
Yeah, they've actually, these are a lot of people who like and support law enforcement.
Yes.
And now are almost shocked to find themselves on the other side of it. It's a real head twister.
Well, there are things that I've seen on the law enforcement side. I know when we went and we finally started holding officers back from going downtown and making formal statements. We gave them the minimum of 2 sleep cycles. That's such a big deal because a trauma memory is so jumbled. Sequence of events are out of order. You'll have an absolute loss of memory on some things sometimes. It just depends on your preparation and your training and the way you've handled things over time. There's so many things that factor into that. And
did you hear what he said? You got to be honest with yourself. How many of you actually practice for what to do in these situations under stress and think you are going to remember. Come on, man. I mean, how's this video? Sound off in the comments. What do you think about this video? Is it informative? I mean, I'll stop it if it's not, right? Is it informative? Do you find value in this video? Because I think it's always good to hear directly from their mouth in terms of their approach to how they intend on crafting, investigating your matter to assist you in getting the outcome of a viable defense after you use that pistol. Let's continue.
To be involved and suddenly be upended where you thought, yes, I did right. You know, as an officer, if something would have happened like this that I had to defend myself, I want to tell my side right now.
Yes.
I want to get it off my
You
chest.
can't wait.
And go,
You can't wait.
yeah, this is urgent. You need to know why I had to do this. And we've learned because of those trauma memories that is not the best case scenario.
Well, I can tell you as a criminal defense lawyer who's tried a number of self-defense cases, the single biggest obstacle for me is trying to explain a statement that my client made at the scene or thereabouts that turns out to be wrong in some way.
Yes.
Unintentionally wrong, but just factually inaccurate, that now gives those that want to be cynical and assume not that he was wrong and mistaken, but that he was lying. You know, you tell one lie, you tell two, then all of a sudden everything you say is a lie, and then you're off.
It's absolutely under question for sure.
Yeah.
You heard it directly from the National Trial Counsel attorney Don West's mouth. How many times have I said, don't make a statement other than officer, I was the victim of a crime. I need medical attention. I invoke my Fifth Amendment rights. I want my lawyer. Officer, I was the victim of a crime. I need medical attention. I invoke my Fifth Amendment rights. Did I say Fourth Amendment last time? I want my lawyer. Why? Ohio versus Rayner, 532 U.S. 17, 2001. This is a United States Supreme Court case. The purpose of the Fifth Amendment, though the guilty may use the Fifth Amendment to their own benefit, but the purpose of the Fifth Amendment to the United States Constitution is to assist innocent people who may not know anything about the complexities of a criminal investigation to keep from making statements that are otherwise innocent that could provide the government to a causal link, or could provide the government a causal link in the chain of connecting that statement to the alleged commission of a crime. Ohio versus Rayner, 532 U.S. 17, 2001, in quoting Grunwald versus Connecticut. You have it built within the 10 amendments to the United States Constitution, otherwise known as the Bill of Rights. You have the right to remain silent pursuant to Miranda versus Arizona, 384 U.S. 436, right? Your Miranda rights. You have the right to remain silent. If you choose to give up that right, anything you say can and will be used against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be provided to you at the government's expense. At the government's expense. What's going on, Christy? Right? That will be provided to you. Now, if you waive your rights and you choose to talk to us, you can stop talking to us at any time and request a lawyer. Right? That's your Miranda warnings. But why even go that far? They're going to read you those, right? And some detectives are slick. they would just start talking to her. They just say, here, just go ahead and, you know, sign that. It just shows you I've read that to you. You don't know what you're signing. Officer, I was the victim of a crime. I need medical attention. I invoke my Fifth Amendment rights. I want my lawyer. That's it. Officer, I was the victim of a crime. It's stating a position, right? I need medical attention. I invoke my Fifth Amendment rights. I want my lawyer. And notice I didn't say it aggressive. I asserted my position. Because all you have, like Don West just said, all you have is one time to make a statement. And that one time you make that statement, that is not, I mean, it was an innocent statement, but it's factually incorrect. And simply because under the influence of stress, you can't recall what happened, or you think you can recall what happened. Or maybe you're one of those people who love law enforcement, and that's fine, but you believe the police are our friends. The police are our friends. If you've watched the case of Gregory and Travis McMichael, who were on trial for the homicide of Ahmaud Arbery in Georgia, you will recall the prosecutor stating, you heard it out of their own mouths. It was primarily their words entrusting the police, but not thinking about that body camera. All those statements that they were making on the scene, thinking that we used to be police, you guys are police, you understand, right? Well, that officer may understand, but that body camera don't understand anything other than what you give it. Let's continue.
So, you know, it's interesting, Rob, that no matter how you get into the system, whether you're guilty of something, maybe not what you're accused of, or you're not guilty of anything at all, you are no longer in charge. You are no longer in control of your life. You are now in the system, and you don't get out until they let you out.
Correct.
And the way you get out is to finish the case. And there's a very clear progression in a criminal case. We're past the arraignment. We're into the discovery phase we're talking about. There will be a point in time, though, where the judge says, enough postponements, enough continuances, it's time to get this case resolved.
Right.
Well, there's only 3 ways to do that, actually. Dismissing the charges, and that's pretty rare if you're that far along, unless the judge suppresses evidence that results in the prosecution having to drop the case, or enough evidence is investigated and revealed that changes somebody's mind. And that doesn't happen very often, because some of these self-defense prosecutions are sort of, there's a political overtone too, and it's in for a penny, in for a pound. So there's a pretty good chance that when you get to the point where you have to resolve the case, it's either going to be by a plea or by a trial. A plea is within the full discretion of the prosecutor. They say, here's what the plea offer is. You may have some limited ability to conference with the judge, but for the most part, the prosecutor has all the cards on that. And I've had cases where there were no plea offers.
And Don, if we're talking about a self-defense case where there was a fatality, the options are essentially first-degree murder, second-degree murder, or manslaughter, or some version of that, depending on how the laws are written in that place.
Yeah, using Florida as an example, first-degree murder is mandatory life in prison if there's no death penalty. Second-degree murder is likely to be life in prison if a firearm was used. It may be mandatory. And manslaughter with a firearm, because a firearm was involved, doubles the potential maximum from 15 to 30 years. So even with a manslaughter, if a firearm was involved, you're looking at a potential 30-year sentence on a reduced plea.
Right, so when you're looking at, when you're talking about the plea process at this point, there's not a lot to go down from looking at 30 years.
Not much room unless the prosecutor is just trying to do anything to get out from under what they believe is a bad case, reduces it so far that there's probation or a misdemeanor or something that is really shouldn't be contemplated usually.
But in the self-defense case, what's tricky at this point is you are convinced you're justified.
Yes.
And now you're going to be thinking, yeah, well, we'll pick up. I want to talk a little about the justification.
Okay, yeah. We're going to take a quick break now. If you'll come back and join us, we'll pick up here with the police stuff. Welcome back to the CCW Safe podcast. Talking with Sean Vincent today and Don West, and taking you through the proceedings in a criminal proceeding leading up to a jury trial. So we were discussing as we went to break plea arrangements and offers from the prosecution to step away from the case with a lesser charge or a lesser sentence.
Yeah, first of all, everyone should know that in virtually every criminal case, there will be and should be some plea discussions. There's no reason not to have some conversations to see if the case can be resolved favorably.
Right.
Not always can it, of course, but there should be some attempts. So never criticize your lawyer for making the effort. That's part of their job.
Yes.
Is to see if there's some way to resolve this case short of trial. And why? Because especially in a self-defense case, a trial is going to result in guilty or not guilty, and it's all or nothing.
Yes.
So there's really very rarely middle ground unless you were to get convicted of a lesser charge, which still means a conviction and still means a likely prison sentence. So if there's a way to avoid that with some meaningful and serious plea discussions, do. But assuming that doesn't happen successfully, then you've got the choice. You either plead guilty as charged because you have the right to do that, but why would you if there's no benefit to you?
Certainly.
Especially if you're not guilty. I mean, some people get so scared that they want to plead almost to anything just to get out from under this weight. They'd almost rather know something's going to happen to them if it's bad.
I've seen,
you know
cops,
what I'm talking about?
Yeah, I've seen cops do this. I've seen prosecutors do this, really pressing somebody that if you don't do this, this is going to happen.
Mm-hmm.
Like the trial is a foregone conclusion.
Using it as leverage.
And using it as leverage. I'm
Sure.
squeezing them, which is,
I bet Sean's been in actual cases where the person wanted to just get it over with. It's almost like willing to take a bad deal before they were willing to face the next step.
You know, well, and that's a good, we're all part of CCW Safe. We all believe in this organization. How you're taken care of as a defendant during that process makes a huge difference. If you have people on your side and you have the resources to make the best defense possible, that period, although still agonizing, waiting to go to a trial, is so much better when you know you've got people who have your back and are guiding you through it and who are making good choices with you based on what you feel. But to your point, you I've seen offers come in right before trial that, all right, hey, today only, take 10 years for some other charge and this whole thing's done. And now you're thinking, okay, maybe I've already had some time in jail. I'm dealing with this ankle monitor. I've already lost my job. I've already gotten divorced, right? 10 years, I can imagine potentially the rest of my life. I can't. And that's when innocent people make very difficult choices, especially if they're not confident in their case or in their representation.
Well, Rob knows first.
Isn't that something to take into consideration? How many of you right now, if you got arrested for he's not exaggerating and to point in the right direction. He's not exaggerating. How many of you think that the criminal justice system isn't going to treat you like you're guilty until proven innocent? How many of you really think that they're going to really believe you? I'll check out your comment in a minute, Chris. How many of you, if you get arrested, your wife will divorce you? Especially after what could be negative publicity. I do solemnly swear to heaven hold you in the good times and the bad, through sickness and in health, till death do you part. Then you get arrested, you lose your job, you lose everything, and your family too. Oh, seems like you don't have anyone on your side. Whew. Chris, you said, my opinion on requesting to go to the hospital to be checked out for stress-related issues to delay some process and to allow the CCW safe team to get on scene. Sorry for the tangent. But I would tell you this, Chris, we go to the hospital to get checked out because we could be under the influence of stress. And if that happens to delay things, okay. You said Kim is coming for you, huh? Well, lucky you, sir. Lucky you. Let's continue.
Firsthand, no doubt, as a investigator among his peers, the notion of a false confession is real.
Oh,
there
yes.
are some people that are just so overwhelmed with their situation that eventually they'll admit to something they didn't do just so the questioning
Just to resolve
stops.
it.
Yes.
Yes. Back to the trial setting, though, imagine the difference between someone who's faced with a bad plea or going to trial, and they ran out of money. They don't have the expert witnesses that they know they need, a use of force expert or somebody to challenge some of the forensic evidence. They've had little or no contact along the way with their lawyer. They don't have an investigator doing the work for their team, compared with someone that has peer support, someone that has psychological counseling available, somebody that has all the resources necessary to hire all of the experts in the disciplines that can be helpful in the case, plus seasoned, experienced criminal defense lawyers. They're completely different positions. And of course, the likelihood of a different result is also very, very real.
You know where the option for pleas start to happen? You've been going for months. We talked about evidence and what's disclosed and what's not disclosed, what you find, what the state brings there. But as you start getting closer to trial, you're going to start having arguments about what evidence actually could be shown to a jury. And if a certain piece of evidence gets excluded, well, all of a sudden that might make a plea real possible to something way less than the worst that you could have imagined.
Some prosecution evidence gets
Right.
excluded.
But then if something that you want gets excluded, all of a sudden that could make not guilty a much bigger long shot. So a lot of really important work gets done in these evidentiary hearings leading up to.
Example, drug use by the attacker, prior criminal record by the attacker, evidence that would suggest that he initiated the confrontation. All of that stuff is fair game unless the judge says no. Now, what happens if the judge says no? Well, the judge says no, you're stuck. You may incorporate that into an appeal down the road saying the judge made these mistakes and my trial was unfair, but nobody appeals a not guilty verdict, right?
Yeah,
you don't appeal how your trial was unfair or you're under-resourced or even that your lawyers weren't qualified unless you get convicted. So now you're not waking up with a ankle monitor, you're waking up in a cell, serving a sentence, waiting for the appeal.
Yeah.
So let's go back to the trial decisions. Well, if you can't resolve the case, you go to trial. If you go to trial, then the evidence is presented by the prosecutor. You have an opportunity to offer evidence. And in a self-defense case, there has to be evidence in the record supporting self-defense. Once that happens, then the prosecutor has to disprove the claim of self-defense. That may be hard, it may not. And a lot of that has to do with, I think, how effective and creative and well-resourced your lawyers are and how experienced they are at actually putting on that kind of evidence in a criminal court. So that's where I think having the right lawyer makes a big difference. in a self-defense case. I've talked to lots of criminal defense lawyers, lots of lawyers that have tried self-defense cases. We all agree they're different. Somehow they're just different than other kinds of criminal cases.
Well, there's so many of those that my goal is to have somebody represent me and somehow get it across to the jury that they're wrong. It wasn't me. That self-defense case, we've taken that completely out of
So what have you
play.
taken off the table,
Yeah, we've
right?
completely
Well, it was
removed
you,
that.
because you
Yeah.
said it was.
Yes.
It was you that fired the gun. It was the fact that you fired the gun that resulted in the death of that person.
Yes.
And the only thing pretty much that's left is why.
Yeah.
Were you justified or weren't you? And even if you think you're justified, the jury also has to think that what you did was reasonable. So the focus goes from the incident that you've basically acknowledged 90% of to what you were thinking, what were the influences, what was the totality of the circumstances that led you to do that. And Sean knows as a social media investigator and jury consultant that what happened at that point extends far into the past and into the future after the incident itself. And I know you do that kind of work helping us prepare cases.
For sure. And what you post online, Cannon will come back to bite you if it's the wrong kind of stuff.
Yeah.
We talked a lot about the Gerald Streetman case. He was a Marine veteran sniper who had put on social media that he had a real problem with people who drove slow. And he actually said, if you drive slow, then I'm a Viper and I'll get you. And he brake checked somebody who had been driving slow. They rear-ended them. They were drunk and now belligerent and issuing verbal threats that they wanted to kill him, and ended in him firing one round from his rifle. And he was on 911 when it happened. The guy had actually gotten far enough to put his hands on the rifle. He told him to stay back several times. Everything's stacking up in his favor, but he's got this reputation as a hothead who'd gotten into trouble before, who very clearly had a problem with people driving slow, and all in that context made a very difficult legal defense for him.
So if the jury doesn't know any of that, he's got a really good self-defense claim, even though he brake checked the guy, even though he may have initiated some of that stuff. Without the jury knowing about the social media and maybe his reputation, he's got a triable case and a winnable case. But what happened?
What happened is that they had a evidentiary hearing on those, what the attorney called a parade of horribles, all his bad acts. There's more than what we've just said here. And the judge in the case just deferred ruling on that. Meanwhile, the guy's in jail and he doesn't know when he's going to get to a trial. It could be 18 months. It could be longer. And so finally, because of the touch DNA on the rifle, the prosecutor brought down to a charge that would, if he pled to it, would leave him in jail for an extra 15, 16 months.
That's a hard decision.
Versus he could be in jail that long just waiting for trial,
Yes.
and then still go to jail for the rest of his life. So
that's an example of a plea agreement that, even though it resulted in a prison sentence, made sense in the context, the risk reward, the notion of, you say no way, I'm going to trial. You could be, what's the word, or cutting off your nose despite your face.
Certainly.
You could make it far worse. So scary stuff. What happens, though, as we're talking about now a little bit more of the sequence of the criminal procedure, you can't resolve the case. The judge has made his or her rulings on what evidence is admissible, what isn't, and it is what it is at that point. So then you have the trial. You pick a jury. Both lawyers participate in that. Opening statements are made first by the prosecutor and then by the defense, and then the prosecutor puts on the case, their evidence. At the end of their evidence, you have a chance to ask the judge to dismiss the charges, saying there wasn't enough evidence to support the charge, even if the prosecutor got the benefit of the doubt on the evidence. That's rarely granted, especially in a homicide kind of case. And then the defense has the chance to put on evidence. They're experts if they want to rebut testimony from the prosecution case, maybe a medical examiner, to offer a use of force expert, which is common in self-defense cases, or anything else that may have arisen in the evidence of the prosecution case that you want to challenge, or even additional areas that you want to supplement. And then there is the million-dollar question for the accused and his or her lawyer. I say $1 million because sometimes it feels like it's worth $1 million if you get it right.
Yeah.
And that's, does the defendant testify? So at that point, when the defendant has to make the decision whether or not to testify, all of the focus of the case will go from whatever this stuff has happened around them to right there. The jury will be looking at that person and deciding, do they like him? Do they believe him? Is what he said reasonable? Basically, would they have done the same thing?
Right.
And it's an enormous decision. It's a decision that is exclusive to the defendant. The lawyer can offer guidance, but the lawyer cannot make that decision.
Correct.
In
Which
fact,
makes some very interesting moments in court sometimes when the judge looks past the counsel to the defendant and say, is this your decision? It's a tough decision to make.
yeah, a lot of judges will stop the proceedings at that point and say, are you going to testify or not? And is it your decision? Because they don't want down the road in some appellate review,
Yes.
the accused to claim that they were forced not to testify or they were forced to testify.
It's good strategy for the defense to keep the prosecuting guessing about whether they're going to have a chance to cross-examine the defense.
Now, if you decide to testify, ooh, they better had prepped you. Oh my God. And I will tell you from firsthand experience, it's kind of hard for your counsel to prep you on what the state or the district attorney is going to ask you on cross-examination. Like, you really need to be confident in how you answer the questions. It's almost as if you have to play this mental chess game to understand the motive behind a question and where the district attorney or prosecutor is attempting to take you. You got to think 3, 4, 5, 7, 9 steps ahead of your next move because of your present move. And depending upon your level of experience in trial or at trial, which for most people is relatively, what, 0? If you decided to testify in your own defense, you would definitely need some prep and practice. Because what you say, trust me, they have a way of upping the ante on that stress. Just letting you know from experience. Just letting you know from experience. All right, let's continue.
Yes. So, but keep in mind, you could get to that point of the trial in a murder trial and there not be evidence in support of self-defense. All of the prosecution witnesses aren't required. And if you can't get it out in cross-examination, it's not in the record. You have other witnesses that can testify, but there may not have been anybody there that can actually put on the record evidence of self-defense. So it may come down to the accused, the defendant, takes the stand to put in the record, yes, I was in fear of my life and I had to respond for fear of losing my own life.
Let's talk about a couple of these other elements of trial. Go back to the first thing you're going to do is, after you've gotten all your evidentiary stuff, your motions in limine about what evidence can come in, what testimony can come in. Now we pick a jury, and I've heard over and over again that I'd rather be judged by 12 than carried by 6. But which 12, right? Yes. And we don't pick juries. What I want you to imagine is I want you to go to the DMV, right? I want you to take 40 of those people, bring them into an assembly area, and then they're going to be randomly assigned numbers, 1 through 40, and we're going to start with 1. Do you want that person on your jury or not? And the only thing you can do is say yes or no, or you can fight for a hardship or a cause strike. But in essence, depending on where you're at, each side is going to get somewhere between 3 and 6 sometimes more preemptory strikes, say, I want this person off, and you're left with what's left.
Tell our viewers how you improve your chances of picking a juror that's going to be fair. If not, I mean, I'm candid enough to say I want a juror that's favorable to me.
Yes.
Fair for sure, but certainly if I get one that I think aligns their views with the case defense, I want that person. How do you increase the odds?
So one of the things that I do professionally is I lead a whole team, and we go and vet these jurors online. Whatever information is publicly available that we can access during the time constraints of this jury selection process, we'll find it, we'll compile anything we think is relevant into a one-page report on this juror so that the trial attorneys can make decisions on this. And sometimes, I'll give you a practical example in a case that we can talk about. Stephen Maddox, who was a CCW safe member, who's given us permission to talk about his case as he wants people to learn from what his ordeal was. We found a juror who was a member of a similar type group, supported self-defense, supported gun rights, believed in self-defense. You don't ask that guy how he feels about guns and self-defense because you don't
ask him in front of the other jurors or the prosecutor.
You don't want them to know. So we just say, that's our guy. We already know he's our guy. We don't need to have any more debate about this. And if we can just keep it quiet, and I believe that guy ended up being the foreman of that jury, and we got a good result.
Nothing illegal or unethical. The whole process is information gathering.
Yes.
There's a lot of gut feeling and intuition involved, but at the end of the day, you're looking for someone that can relate to the defendant or the issues in the case. Of course.
Right. But you if you're not careful, I guess what I'm saying is, sometimes you get stuck with the crazy cat lady who still has an Elizabeth Warren sign in her front yard, and she's going to stand in judgment of you too. You get who comes to the court that day.
It's a real crapshoot.
And you eliminate who you really don't want, but you're left with what you got, and you got to make the best case you can.
You don't know who's going to show up because you don't know who's been summoned. You don't know of the bigger group which ones are going to be assigned to your panel.
Right.
And sometimes you don't even know if you'll be able to reach the jurors in the panel that you really like, because they're too far back,
Right.
That because of challenges or
They got
other issues.
narcolepsy, and they sleep through half the testimony, or they're just not paying attention, or they're worried about their kids, or whatever. You don't know a lot of these things. It's a pretty big gamble.
I used to think that as an egotistical young lawyer that I could save the day with a compelling and captivating final argument. Just give me put me in, coach. At the end. Man, I am humbled from that now. I really believe now, although you need to be effective at every step, and certainly being effective in closing is critically important. But in my view now, looking back on some of these cases, jury selection to me, first and foremost, is how you have to start the case to get people on the jury that will at least listen, will understand, and be willing to apply the law to your facts. And
you can't win a case in jury selection if the lawyer's not good, if the case isn't solid, but you can definitely lose it.
That's a great observation.
Don't do that,
Yeah, critically important. And we do that as CCW Safe. We provide our members with the resources necessary to go that extra step, whether it's juror vetting and witness vetting.
It is, and it's such a big deal. I mean, there's so many moving parts that have to be addressed, and it's why our big thing is that unlimited defense fund. We're not withholding Sean because that's gonna cost a little bit more. It gives us the best chance to give you a proper defense. Whereas we've got competitors that we come here, and we were talking about the plea deal a little earlier, that all of a sudden you've taken a plea deal because of that. Even if it's just that fear, I stand right here and I know what I did was right, but man, this is a safer bet than the gamble of what I could lose.
And sometimes you can even plead and claim you're still innocent. Yes. Still plead to get the case over with.
An Alford plea,
best
yes,
interest,
absolutely.
Right? So what happens with some of the other competitors at that point?
Well,
I know. Hands up. Sorry.
Yeah. Number one is now I have to pay back all the fees that they've invested in my defense because now I'm guilty. there's some of them that if I go, well, I want to appeal this.
This is
This is
Right.
important.
Appeal this if it's a plea deal. But if it goes to trial and I say, you know, that it's still not right, I disagree, I'm innocent, let's appeal this thing.
Mhm.
We have competitors that say, well, we'll take that appeal on, but you have to pay back for that initial loss.
Let me talk about that for a minute, because that is
Absolutely.
near and dear to my
Yes.
heart. Because sometimes I'll talk to a colleague or someone that crosses paths with, and that's a member of an organization
Right.
other than ours, and I'll say, well, do your benefits include an appeal?
Yes.
Do they include a retrial after a successful appeal? Do they include a retrial
Listen.
if the judge grants a mistrial
Mistrial,
during
yeah.
the case? And a lot of times they say, good question, I don't know. Well, you got to take a look, because if anything, CCW Safe is transparent in that. And yes, if you go to trial and lose, CCW Safe will pay for the lawyers and the expense of the appeal.
Yep.
If you are successful in appeal, CCW Safe will pay for the cost of the retrial, which means starting over. It's
Yes.
not like you pick it up where you left off. You
Yes.
start over again, new jury. It could take weeks or months. If something happens during the trial, if a witness says something they were not allowed to, mentions evidence that was excluded, if the prosecutor is guilty of misconduct and the court grants a mistrial, CCW Safe pays for the new trial. And what happens the most, I think, in cases is that at the end of a hard-fought case, the jury can't be unanimous for some reason. I don't know why it is. Maybe a bad juror got on there, or maybe the evidence was that close, but they can't reach a unanimous verdict. And when that happens, after some period of time and some cajoling by the prosecutor, the judge, the judge will grant a mistrial.
Right.
And that means it all starts over. And
I'll tell you in a minute, Jacob.
Yes.
You know, it's whether you're going back for a second trial for appeal, but I think self-defense cases, because they're so hinging on what was in their heart when they made the decision to pull the trigger.
Mhm.
If there's one person who really believes they did the right thing and someone who really believes they murdered somebody, that's how you get a hung jury.
Yes.
And this is the kind of case that's built for hung juries.
You know, and that's what impressed me so much about CCW Safe when I met these guys. So transparent, and there was no question. Yes, we pay for in addition to all of the expense to get to trial and to finish the trial. If things go badly, it might not be your fault. You might still be innocent after all of that, but somebody else caused the problem. There may have been juror misconduct, or who knows. And you do need to appeal, then CCW Safe provides the funding for that. And at the end of the appeal, typically the judges on the appellate panel don't dismiss the case. What they do is decide, yes, your trial was unfair.
Right.
Because of this witness issue, this juror misconduct. The judge may have made an error in the jury instructions. And they say, yes, your trial was unfair. We reverse your conviction and remand it, not for a dismissal, for a new trial.
Right.
So you start all over again. And to me, as a defense lawyer who's looking for the ability to try.
Yes, I'll put the link in the description. The link is in the description. I'll drop the link now.
I'm really impressed with that. And I said that to myself before I ever connected with these guys. Just kind of looking around, and I'm so privileged, I think, to have joined this team.
It is so solid. And the decades and decades of experience that are built in, guys that are able to come in and not base it on the, oh my gosh, this is going to cost a lot of money. And it's paid so many dividends for us. You know, we've grown leaps and bounds as people have found out and understand what to look for and what are the coverages that are really absolutely necessary. It's just, I knew.
And don't forget the stuff that you do, Rob, and what Gary does,
Certainly.
and Justin and others, is create an informational base that helps people that are interested in continuing with their training, first and foremost, how to avoid being in the problem to start with. How many shootings that don't happen because of somebody wanting to get better.
And we've had members call in and go, I probably would have, had I not heard this podcast, or had I not read this article, had I not had this information made available to me, I would have made a poor decision.
How gratifying is that?
Yeah,
I
it's
mean,
fantastic.
And that might be the most important lesson to take away from this whole conversation today. We've just outlined a nightmare process.
Yep.
Even you don't win a criminal prosecution as a defendant, you survive it,
Yeah.
right?
Well said.
And you don't survive it without bruises. It's a tough process, and you have to pick up and rebuild your life, even if you're acquitted. And from being involved in so many self-defense cases, some of them with you, Don, and for CCW Safe researching so many cases that have been high profile public, you see good people make very similar mistakes.
Okay, so let me explain. It's not a coupon code, all right? When you click the entire link, all right? When you click the entire link, matter of fact, let me click the link. Since you want a coupon code, I'm going to put it in there for you because that's right. When you click the entire link, this is the particular number that goes straight to me. I got no problem giving that. That's fine. Right? Is there a case that somebody defended themselves and won? Yes. That is the Stephen Maddox case. The Stephen Maddox case, a black man accused of first-degree murder in the South. CCW Safe helped him get an acquittal, a not guilty verdict, right? Heater. That's the coupon. That's the code you could put in right there, right? That Sectricon, ccwsafe.com/Sectricon is just the link for my company, right? But that number right there, try that number there, okay? Try that number there, and it should go through. Let me know if it does, okay? Yes. Look, what he said was so important. You don't win a self-defense case, you survive it. Man, first-hand experience. He is correct. You lose a lot. You have to rebuild. Man, walk away. Walk away. And what did I tell you about the appeal? Did I tell you they cover the appeal? Because in this day and age, you could find yourself being found guilty just to save face, just because of politics. You could find yourself in that situation. Come on now. It's almost over. Here we go.
Over and over again. And how many of even the cases that are not guilty verdicts, where the defender is found to be justified, you can still find opportunities they had to avoid the shooting. And if we can save someone a prosecution, even if it results in an acquittal, and save somebody's life, also, by the way, that's the important work.
The win.
Yeah, that's
the win.
That's the big reason that we press and we talk about disengagement, de-escalation, removing yourself completely from the problem, or never putting yourself in that problem. I don't have to pull in front of the guy and brake check him.
I don't have to get out of the car.
I don't have to get out of the car. Yeah, we've had cases that we've studied where you've had both enraged drivers pull over to the side of the road, and the one in the lead car is the one that's saying the guy behind him is the troublemaker, and then the guy in the lead car gets out with a gun. That's an issue. That's something that's going to be really difficult for you to overcome. So it's just something that we feel is really critical, is to get out information, bits and pieces for you guys, so that you can better equip yourself to handle these situations as they come up in your day-to-day life. Don, do you have any quick takeaways for us?
You know, I think you said it all right there, that if you can avoid it, avoid it.
Yeah.
If you can't, act decisively, definitively, act within the boundaries of the law.
Yeah.
And get some help.
Thanks.
And we're there. We've got your back.
Sean?
I just want people to know that if they're with CCW Safe, what they've got is confidence.
Yeah.
They've got a good team behind them, and they can have confidence that the best case that can be made is to be made for them.
I hope this was valuable information for you guys. We appreciate everybody for tuning in, and we can't wait to see you again next week. Thank you, guys.
Thanks, Ron.
I was muted. So what do you guys think of that video? Did you find that valuable? I know I did. I know I did. And I'd rather you hear directly from their mouth. Now, Jacob asked a wonderful question. Shouts out Jacob Knoll, Viper Defense, okay, down there in Southern Illinois. Friend of the show, always. What happens if you're a member of both CCW Safe and USCCA? One, you have the right, as well as anybody else, to be a member of both. And what you choose to use is on you. Me, I'm going with CCW Safe. I'm just going to go on ahead and just say it. Don't get me wrong. USCCA is USCCA. But I'm using CCW Safe. I'm using CCW Safe. You did? It did work. Okay, good. You said carry plan and home defense plan. Sorry if it's a stupid question. I didn't get your... What were you asking? Right? I just choose to go with CCW Safe. The reason being, the major selling points for me were, one, they got a record of wins at trial. Two, if I get found not, strike that, if I get found guilty, will they still cover me on appeal? Yes, you heard them say it out of their mouth. And he even talked about the reasons you could have been found guilty, especially in this political climate. Especially in this political climate. See, me being a criminal justice practitioner, some people get excited at the arrest. Some people get excited at the dismissal. And I'm talking about for expungement purposes because you forgot to expunge the record. So the arrest still comes back to haunt you. Some people get excited at the not guilty verdict, and you should still expunge that case, though. But some people obviously get pissed at the guilty verdict. You're supposed to, right? Especially if you're truly innocent. And you know you're innocent, but you may not understand the complexities of the trial, or the jury just has it in for you. And all of a sudden convicts you because maybe they don't like the air of confidence that you exude. Using big words, right? The air of confidence that you display or you give out. They take your confidence for cockiness. Oh, we're going to send him a message. And all of a sudden you're convicted of something where the evidence may clearly show that you didn't do it. Will the judge set aside the verdict and enter a not guilty verdict? Or will the judge just trust the word of the jury, which most do, get to the sentencing phase, sentence you, and then what? Then what? Who's going to cover the appeal? Some companies may turn their back on you. As soon as you're found guilty, well, as soon as you're found guilty, you're guilty and you're like, ah! How did I get found guilty? How did I get found guilty? I did everything I was supposed to do. I'm not responsible for why the evidence was picked up from the scene by people coming. That man had a gun. But what if his friends came and picked up the gun and ran off with it and they couldn't find him? What do you do? No, don't leave me. You said you were going to have my back. I really didn't do it. I need your help. I need to be able to appeal this, and I can't afford it. That's why I paid for your services. Well, I'm sorry, but we can't cover you. You were found guilty. Oh, man, I remember watching this live one time, and Instructor Mike talked about appeals and CCW safe, but I didn't trust him. I didn't think about his word. I didn't believe him. Who is he? He's no one. Or worse yet, he's black. I'm white. Black people have a different view of the criminal justice system. I'm white. So I probably don't have to go through what he and people like him have to go through. But then you find out in your given case where you're a white male and maybe you had to defend yourself justifiably against a black male in this political climate. What do you do if you're found guilty and you're truly innocent? What do you do? You heard CCW Safe say they cover you on appeals. Or what if you're a male and you had to use force against a female? Ooh. What are you going to do? Now, I heard Faith say, scream, and I'll give you $1,000. I'm not kidding. You didn't hear me scream? Gail, please drop the Cash App link, the Zelle link, because with $1,000, do you know how many children's books I can give away? Ow! Drop it. I'm just saying, put your money where your mouth is. No pressure, but you said do it. ccwsafe.com/Sectracon. ccwsafe.com/Sectracon. That is who I trust my life with. In fact, I'm using them now. And they're doing a great job. I'm just saying. Look, I hit the note. If she does it, cool. If not, that's cool too. I'm just saying. Right? Who knows? Who knows? He said, I wonder if CCW Safe would have covered the McCluskeys. I don't know who that is. Maybe I need to do more research. All right, here we go. This has been a great show. I'm sure she's gone. I'm sure she's gone. This could have been a troll page or some other page. I don't know. You said, well, I know what I want for Christmas now. Jacob, I'm just saying, right? I mean, we could have an offline discussion about all this because on one side, I get it. But on the other side, I'm just saying. I'll check it, Gail. I will. On one side, I get it. On the other side, I'm just saying. Who or what agency am I putting my life and freedom in if I am a conflict resolver and an avoider, if I am cautious about the situations that I am in to make sure that I don't have to use it, but if I have no other choice and I do use it because I wasn't looking to use it, but it happened upon me and I defended myself and or my family. Oh, I remember that. Okay, thanks, Gene. What would I use? CCW safe. Why? Because they're going to still cover you if things go bad within the context of that criminal trial. There's so many different things that could occur. You don't know them all. I don't even think you're going to try to Wikipedia and find out. So many complexities. I hope you all found this show valuable. Like, comment, share. Like, comment, share. The link is in the description. You said you're still not sure why there's a separate home defense plan. Because I'll tell you why. There's a separate home defense plan, to my understanding, because there are some people, like in Illinois, you could have a concealed carry license, right? And this concealed carry license allows you to be able to carry inside your own establishment, property, whatever the case may be, and outside in places allowed by law. But some people only want, at a minimum JFB, $20 per month. If you choose the Defender plan, it's only $20 per month. Okay? Some people only want to own a gun just for the home. They don't want to carry it out in the streets. If that is the case, the home defense plan makes sense. It makes sense. Check it out, ccwsave.com. If you got any more questions, you can always text me, 773-644-5000. 773-644-5000. Okay. ccwsave.com/Sectracon. ccwsave.com/Sectracon. This has been an informative live. Shouts out to Gail, Christy, JFB, William, all the moderators, Jacob, Gene, Tawana, what's going on? Faith, I still didn't get the $1,000. You said you was going to give it. You know how many children's books I could have given away if you would have did that? I'm still looking for it. I'm still looking for it. Did you do it? Did you do it? Why am I looking? Why am I looking? Hey, I ain't gonna lie. I was looking. It's all good, though. It's all good. All right, you all. Take care. Take care. Have a wonderful night. You all be safe. Next time we'll drop the link and we'll have you all come up. Peace.
What's going on, you? This is Instructor Mike. You can follow me on Facebook at Mike Brown or Instructor Mike. Follow me
It
on
could be you as a citizen, and you walked up and you see somebody. Look heavy? I don't know. special. That must be. But it's good to know that this can handle the high pressure rounds of the flooding.
Ready to go. Make eye contact with me. He's still trying to get it open a couple of times.
So challenging.